So what is the collateral source rule and why does it matter? The collateral source rule states that benefits received by the plaintiff from a source wholly independent and or collateral to the wrongdoer will not diminish the damages otherwise recoverable from that wrongdoer. So let's break that down by using an example. You get in an accident, you go to the hospital charges you $10,000 as a bill. You have health insurance though, and the health insurance steps in, negotiates that bill down. They pay $2,000 and you owe a $300 copay. So you really only owed $2,300 for that $10,000 bill. Well, if you go to trial under the collateral source rule, you can present that $10,000 bill as what your damages were and not have to mention the $2,300. And in fact, the defendant can't even bring up that you only owed $2,300, even though the bill was originally $10,000. This allows a plaintiff to fully recover for the damages that they received as a result of the accident, and it doesn't effectively punish them for having a health insurance plan that covers them in the event of an injury. Now, the Alabama Supreme Court abolished the collateral source rule in 2010, and prior to that, the Alabama legislature was trying to pass laws that would hem this up or actually block the collateral source rule from applying anyway. So this has been a long time coming in Alabama, and it's now officially gone since 2010. So what does that mean? Well, that means in Alabama, if the plaintiff puts forth evidence of their full retail medical bills, that a defendant then can come in and put forth the evidence of what the actual bills were as to what their health insurance paid and what they had to pay in copays. This can severely diminish the value of a case, and in fact it can even make you come off as looking like you are being misleading to a jury. Many states in the U.S. still have the collateral source rule and don't allow a defendant to present evidence of what health insurance pays, and some of those states are our neighbors, including Georgia and Florida. So this isn't a universal thing that all the states have gotten rid of the collateral source rule, and it's sort of up to the individual to decide how they feel about which one is more fair. I mentioned in a previous post that the plaintiff is not permitted to bring up evidence of the defendant having auto insurance that would cover the accident during the trial, and in fact if they do, the trial can be mistried by the judge and they have to strike a new jury and do the whole thing all over again. So it's a big deal that you can't mention car insurance. Now, we're here on the flip side of this, where Alabama has stated collateral source rule no longer applies and that the defendant can bring up your health insurance as part of trial, but you're still not permitted to bring up their auto insurance. So I'd love to hear your thoughts on this. If you've got any questions, let me know, and I'll be glad to try and clarify anything that is still as clear as mud. My name is Nelson Johnson. I'm an attorney licensed in Alabama and Georgia, and if you would, please like, follow, share, and I'd be glad to answer any questions you may have.